Hi, I'm Jacques Jansen, and this is my group relating to divorces, maintenance matters, and rights to children, and children's rights. I regularly receive questions regarding the position of divorced and unwed mothers and biological fathers regarding children born in or out of the wedlock, and in general what their position is. In this regard, I thought it would be a good idea just to discuss quickly Section 19 of the New Children's Act, which relates to the parental responsibilities and rights of mothers. The Act states that the biological mother of a child, whether married or unmarried, has full parental responsibilities and rights in respect of the child. If the biological mother of a child is an unmarried child who does not have guardianship in respect of the child, and the biological father of the child does not have guardianship in respect of the child, then the guardians of the child's biological mother is also the guardian of the child. So this position is exactly the same as it was prior to the promulgation of the New Children's Act. This section, that part, does not apply in respect of a child who is the subject of a surrogacy agreement. Surrogacy agreements do not fall under this article. The question I probably receive the most is, what is the parental responsibilities and rights of married fathers? The biological father of a child has full parental responsibilities and rights in respect of the child. Now listen carefully. If he is married to the child's mother, or if he was married to the child's mother, and listen carefully now, at the time of the child's conception, so when they were having sex and making the child in question, if he was married to the woman, that's at the mother at that time, then he has full parental responsibilities and rights, the same as the mother. Or if at the time of the child's birth he was married to the mother, or any time between the child's conception and birth. The parental responsibilities and rights of unmarried fathers are clearly set out in the new Act. In terms of Section 21(1), the biological father of a child who does not have parental responsibilities and rights in respect of the child in terms of Section 20, this is what I just discussed before, acquires full parental responsibilities and rights in respect of the child if at the time of the child's birth he is living with the mother in a permanent life partnership. That is, the section provides, gives effect to the fundamental right not to be discriminated against based on your marital status. So if you are living together as life partners, then he acquires full parental responsibilities and rights in respect of the child. If he, regardless of whether he has lived or is living with another, one consents to be identified or successfully applies in terms of Section 26, which I will discuss in a later on video later on, to be identified as the child's father or pays damages in terms of the customary law. He contributes or has attempted in good faith to contribute to the child's upbringing for a reasonable period, and contributes or has attempted in good faith to contribute towards the expenses in connection with the maintenance of the child for a reasonable period. Now, this section does not affect the duty of a father to contribute towards the maintenance of a child, and you must never think that a maintenance order or an inquiry in the maintenance court will be influenced by the section, because it won't. If there is a dispute between the biological father, now this is very important. The question is usually, what's going to happen? What is the biological father of my child with whom I've had a relationship years back, who I was married to or never married to, or it was maybe just a one-night stand? How will he attempt to enforce any rights that he perceives to have? Now, here is what the Act says. It says, if there is a dispute between the biological father, referred to in subsection 1. Subsection 1, I've discussed it. It's the one that if at the time of the child's birth he's living with a mother in a permanent life partnership, or regardless whether he has lived or is living with a mother, consents to be identified, contributes in good faith to the child's upbringing or reasonable period, or contributes for reasonable expenses. And that's the person, that's the guy we're talking about. If there's a dispute between the biological father, referred to in subsection 1, and the biological mother of a child with regard to the fulfillment by that father of the conditions set out in section 1A or B. Now, I've just discussed 1A or B, 21, 1A or B. If there's a dispute whether during the child's birth he was living with the mother in a permanent life partnership, or if there's a dispute whether he consented to be identified, or successfully applies in terms of section 25 to be identified as the child's father, or whether he has paid damages in terms of the customary law, or whether he has contributed or attempted in good faith to contribute to the child's upbringing for a reasonable period, or if there's a dispute whether he has contributed or has attempted in good faith to contribute towards the expenses in connection with the maintenance for the child of a reasonable period. Now that dispute is not going to a court. That dispute, the Act says, must be referred for mediation to a family advocate, a social worker, social service professional, or other suitably qualified person. So there goes the whole fear of being dragged to court by the father of your child. It's going to be informal. It's a mediation. Google the word mediation, and you will see, if you go on YouTube, you'll find examples of mediation. It's a process whereby a neutral person with suitable skills attempts to bring the parties together, tries to settle the disputes between you, and take my word for this, you will be surprised how effective mediation in any arena can be. If you are not happy with the outcome of the mediation, you can have it reviewed by a court. Now, this section, what I've just discussed, applies regardless of whether the child was born before or after the commencement of this Act. So don't worry about the fact that your child might have been born before this Act came into force. It still applies.